co-chair this panel, the second one in your very interesting conference, which hosts two legal scholars who are also dear friends, both engaged with questions of human rights daily, just as other people here, and from wider perspectives. So I will start with introducing them. Unfortunately, Professor Stone could not, for some reasons, could not make it for today. And so we have these two presentations. Will be a bit longer than the others, but we will finish anyway 8:15. Excuse me, 17:15. Okay, so we start introducing our speakers. Professor Shai Lavi. Shai is a director of the Leer Jerusalem Institute and professor of law at Tel Aviv University. Professor Levy earned his first and second degrees in law and sociology at Tel Aviv University and his doctorate in law at the University of California, Berkeley. His area of specialization is the sociology of law and legal theory. He explores bioethical issues from historical and contemporary perspectives with an emphasis on the issue of technology and the beginning of life and at its end. He also engages in comparative research in Germany, Turkey, and Israel on issues related to legal regulation of the body and the tension between religion and secularity. His book on the end of life, The Modern Art of Dying, a history of euthanasia in the United States, won the 2006 Sociology of Law Distinguished Scholarly Book Award of the American Sociological Association. I think that this is enough. There are all kinds of other awards and honors, and I will move to introduce Dr. Shakargy. Sharon, Dr. Sharon Shakargy is an associate professor at the Faculty of Law at the Hebrew University of Jerusalem, specializing in private international law, family law, and comparative law. In her work, she studies the legal manifestations of identity and how they have changed over time. She focuses on questions such as the cross-border regulations of marriage and divorce, the regulation of alternative spousal relationships, the recognition of non-romantic relationships, surrogacy agreements, and the cross-border protection of people with disabilities. Sharon is the manager of the Israeli Family Law Forum. She served as a visiting researcher at Harvard Law School, a Fulbright scholar and Grotius research scholar at the University of Michigan Law School, and as an academic visitor of the University of Oxford. So, Shai, please start. The floor is yours, and we are. I would like just to mention again your topic, the groundlessness of law and Genesis 3, guiding the perplexed.
Thank you so much, Ruth, for this introduction. I would also like to thank the organizers for inviting me and for putting this wonderful conference together. As we all, I too regret the fact that Suzanne Stone, dear friend, is unable to join us today, and I'm thrilled to be in the same panel with Sharon and to see many good and old friends, as well as new, I hope, friends and colleagues here on the screen. My paper, I should say, is based on a collaborative work with Yuval Kremnitzer, to whom I'm ever so grateful for this collaboration. To be on the safe side, whatever you like in my talk is his ideas, and what you don't agree with, or even worse, are most probably my own. I should also add the usual caveat, but important in this conference, and especially in the presence of teachers and scholars in the field, that in the spirit of, I guess, this conference, my talk is given despite the fact that I'm not an expert in biblical law, nor in Jewish thought, but I'm very much interested in the underlying questions that have already been raised in the previous panel. One way, so yes, I should also add, because I've seen this now on the chat, I've been having some technical problems. It's not that I'm not on the screen, I am on the screen, but I'm working with two different devices. So if you pin, there's an option of pinning the camera where I do appear rather than the black square where I don't appear, and then you'll be able to see me. I'm afraid that if I try to do both, there will be interruptions. Is that, okay, I'm sure you'll manage. Okay, so in a way, my paper can be read as a follow-up to Sam Moyne's. I share his skepticism about the ability of doing the Bible and human rights. I'm with him on the idea that we need to be, in some ways, have more, perhaps, not pride in our tradition, that's not the point, but find in our traditions things that we can find, perhaps, in the human rights tradition as it has come down to us. I think that Sam raised this as an open question about what exactly we can find in our tradition. And in some ways, my paper is an attempt to answer that question. What is it in the tradition, the biblical, so to speak, tradition that is worthwhile? And to give you the short answer, it's the idea of tradition, which in this paper, I will be talking about in the sense of the groundlessness of law. So the authority of tradition as a groundless authority. So my paper, in a way, is a response to the provocative title of the conference, The Bible and Human Rights. The title is provocative because it suggests an affinity between the Bible and the concept of human rights. There's a long tradition that has emphasized this affinity. Among others, it appears in the writings of 17th century political theorists who were part of the Protestant Hebraistic tradition. Tradition has been recovered in recent years in the excellent work of Miral Jones and many others who have returned to the Hebrews in order to demonstrate what important role the Bible has played in the emergence of modern political thought, and specifically the idea of human rights. This important line of scholarship notwithstanding, in my talk today, I would like to challenge the affinity between the Bible and human rights in two interrelated ways. First, I would like to argue that what may be most interesting for us contemporary readers of the ancient tradition is not the way in which it reinforces contemporary understandings, but rather in the way in which it departs from and challenges the modern liberal mindset. Specifically, under the following reading, the Bible rejects the natural law tradition and the core concepts of rights. In contrast, the Bible opens up possibilities that are otherwise not easily accessible to us. Second, and closely related, I wish to question the immediate identification of the Jewish Torah with the concept of the Hebrew Bible that the Hebrews established, and that the title of this conference, though not necessarily its organizers, reinforce. So Leer already pointed out to the tensions between Hobbes and the rabbis, and I think that this is also an important direction. This misleading identification assumes that the task before us is to go back from, I don't think anyone is taking this seriously, but at least the title, to go back to the bare biblical text, or the scriptura, and find within it meaning. As a Hebraist tradition of political thought proves, these two aspects reinforce each other. It is only if one strips the Hebrew Bible of its historical and traditional meaning that one may find within it grounds for human rights. In counterposition, I would like to return to Genesis through the traditions of its readings. In my case, through the Middle Ages, and specifically Maimonides' reading of Genesis and beyond. My insistence on reading the Bible along with the tradition should not be understood as a romantic or conservative move à la Burke, for example, back to tradition as some stable sense of authority, but precisely in the way in which tradition and the authority of tradition can be a critical point of departure, opening a discussion on the groundlessness of law. Okay, so since the key idea for my talk today is the groundlessness of law, I should begin with what I mean by this. The concept sometimes also referred to as the unwritten law is key here, but unwritten understood not merely as that which is unwritten, but that which is unwrittenable. It cannot be written because it cannot be formulated in the ordinary language of general rules, universal rules and principles, the language of the logos. To speak of the groundlessness of law, we must hearken back to the language of the mythos, or at least this has been a common way of going of doing this, but not in order to escape the bounds of rational philosophical thinking, but in order to push these bounds to their limits. So one may begin with, just very briefly, with the Greeks and their idea of the unwritten law, that is physis, as opposed to nomos. Physis is a not man-made law, but the force of nature, of growth, of exuberance, orge in Greek, the source of life. It is the law which, as we all remember, Antigone invokes when she defies Creon's posited law, acting in the name of, quote, the unwritten and unfailing ordinances of the gods. For these have life, not simply today and yesterday, but forever, and no one knows how long ago they were revealed. It is on account of this law that the chorus sings Antigone's praise, as yourself, a law to yourself, living alone among mortals, you will step down to Hades. Today, we no longer call this law by its originary name, physis. Since the Romans, we have replaced physis with natura, and the unwritten law and its immortality with natural law and its eternity and universality. Philosophy was converted to Christianity, and Aristotle baptized to Aristotelianism. Natural laws thus became synonymous with an unwritten law and contrasted with posited law. But, and here's the first part of my argument, counterpositing natural law and positive law has turned out to be an entrapment. It creates a set of binarisms still prevalent in contemporary jurisprudence, through which we think and which limit our legal imagination. Will versus reason, force versus morality, autonomy versus autonomy, territoriality versus universality, transience versus eternity, etc. So my the purpose of this intervention is to open a possible horizon to think of law beyond limitations of natural law. To do so, I will turn to the story of the origin of law, or rather, in this case, the groundlessness of law in Genesis. Jewish Torah. Here we must hear Torah and not mythos. So Torah as a teaching, as a tradition of teaching, as a teaching of tradition, differs dramatically from Greek myth, which is a point of reference when it comes, especially when it comes to the Middle Ages and to Maimonides, which is where I'm heading, at least on 2 points. It's metaphysics and its ethics. And here, obviously generalizing, Greek metaphysics, as it has come down to us, assumes an unchangeable nature, a world that always already exists, and rejects the idea of a created world. In contrast, the biblical myth of Genesis tells the story of creation. Similarly, Greek ethics, again, as it has come down to us through Aristotle, tells the story of unchangeable law and unchangeable ethics. In contrast, Jewish law is a revealed law, a Torah received by Moses at Mount Sinai. Obviously, the ethical and the metaphysical aspects are linked. For the Jews, as opposed to the Greeks, the world and the law have emerged ex nihilo, and thus open the possibility of an authority that is not immediately intelligible to humans. It is here that we can begin to see a conceptual space open for the authority of tradition, the authority of the groundless law. Okay. Skipping a bit, there's a great quote here from Hermann Cohen, religion, where he writes, in Religion of Reason out of the Sources of Judaism, he says, quote, what the Greeks called unwritten law, the Jews called written teaching, Leer. Okay, so now I jump, so to speak, into Maimonides, and I do this in fear and trembling before some of the authorities here who have done work on Maimonides. But I guess if the Bible is open to these kind of interpretations, we can also open up Maimonides' guide in this way. So a lot of this will be familiar, but is important for setting the context. The most renowned academic reading, there are two kind of readings of Maimonides. The most renowned academic reading of the guide is Leo Strauss's illuminating interpretation and his persecution of the art of writing. For Strauss, Maimonides was a committed Aristotelian, committed to the natural law tradition, but was barred from stating so explicitly because he feared to be accused of heresy. Thus, the book, as Maimonides himself claims in the introduction, was written with hints and riddles that only the wisest of his readers could decipher. Between Athens and Jerusalem, Maimonides for Strauss was clearly an Athenian and a Jerusalemite only in disguise. The alternative dominant reading of Maimonides does not reduce Maimonides' thinking to natural law, but acknowledges the way in which Maimonides' theology offers a variation on Aristotelian philosophy without negating basic philosophical principles. Under this reading, Maimonides seeks to offer the best possible interpretation of the Jewish tradition within the bounds of reason. While Aristotle and the philosophers who followed him believed that the world was not created but was eternal, and that humanity could reach the good life without divine revelation, Maimonides believed that all these were possible, and though nothing in these ideas was philosophically necessary, all were feasible alternatives. Nothing in Jewish theology directly contradicts Aristotelian philosophy, but the former cannot be reduced to the latter. According to this reading, Maimonides is professing a Jewish theology within the bounds of Aristotelian reason. Moshe Halbertal in his book really opens up many more interpretations of Maimonides' guide and offers his own. Here, I want to offer yet another interpretation, one that asks the following: how can Maimonides be both a thorough philosophical naturalist in the Aristotelian tradition and a Jewish traditionalist committed to the divine law in scripture? Can there be an autonomous use of reason that does not conflict with the heteronomous authority of tradition? So the alternative reason that I wish to offer is a stronger reading. In it, Maimonides is challenging, this is key, something very fundamental in philosophical thinking as we have come to know it since Aristotle, and is questioning whether in the final analysis, the natural law, that is human reason as the grounds of law, may serve as a plausible philosophical ground, not only for Jewish law, but for law in general. So basically what I'm trying to, my reading of Maimonides is a reading that puts him as an advocate of the groundlessness of law, and as someone who is trying to give a philosophical account of the importance of tradition and the authority of tradition as a groundless law, which I think has direct bearing on our conversation of human rights, as I will suggest. So I think those of you who are familiar with the guide will be also very familiar with the opening of the book, and part of the methodology I'm suggesting is reading the beginning with the end, as well as the ethics with the metaphysics. I won't be able to elaborate on all of this today. Happy to address some of this in the Q&A. Maimonides opens the book, I think, with a dramatic statement about the groundlessness of law. And it begins with a question that was posed to him by what he calls a wise man. Basically, the question is, how can the eating of the fruit of the tree of knowledge be a sin? How can the human desire to be like God be construed as evil? Now, it is a thing to be wondered. I'm hesitant to share a screen because I understand, first of all, host disabled participant screen sharing. That's one reason. Nope.
Shai, now you can do it.
Okay. Here we go. Now, you can tell me whether yes, I think this is not quite working. Can you see this?
We can see that something's coming.
Oh, that something's
Yes,
coming.
it's there.
Okay, so the riddle. Now it is a thing to be wondered at that man's punishment for his disobedience should consist in his being granted a perfection that he did not possess before, namely the intellect. This is like the story told by somebody that a certain man from among the people disobeyed and committed great crimes, and in consequence was made to undergo a metamorphosis, becoming a star in heaven. Note that Maimonides' question could have never been raised by the Greeks. The mortal wish to imitate the gods is precisely the origin of human vice in the Greek world. The answer lies in a close and novel reading of the biblical text. The prohibited fruit is not the fruit of the tree of knowledge as such, but the fruit of the tree of knowledge of good and evil. Maimonides immediately clarifies knowledge of good and evil is distinct from ordinary knowledge of truth and falsehood with which humans are naturally endowed. Human knowledge of good and evil is a matter of custom rather than a matter of truth. We learn it not through reason, but through tradition. We do not say of murder or any other vice that it is false, but rather that it is evil. The origin of evil lies not in hubris or in temptation, but rather in humans' ability to tell good from evil with the same clarity and certainty that they can tell truth from falsehood. If for the Greeks, the original sin of stealing the fire of knowledge is the stealing of fire of knowledge from the gods, for Maimonides, it is having lost the fire and wandering in the darkness with respect to the question of good and evil. If this is humanity's fall, where lies its redemption? It is precisely because human reason cannot ground morality that there is a need for divine revelation, for the Torah. But for Maimonides, the divine revelation does not take the form of posited law nor of natural law. Torah is binding not simply because it is, of course it is, the will of God, nor only because it is, and of course it is, divine reason. It is first and foremost a received tradition. We ordinary mortals have direct access neither to God's commandments nor to his reason. Jews receive the tradition through the chain of transmission, linking back to the giving of law at Sinai. It is only the transmission of the Torah which can undo the original sin, that is the originary source of sinfulness, which is human limitation on direct knowledge of the truth of morality. It is here that Maimonides quotes an ancient midrash. Let's see if I have it. Yes, just a second. Here you go. This is a wonderful passage. Among the amazing dicta, whose external meaning is exceedingly incongruous, but in which, when you obtain a true understanding of the chapters of this treatise, you will admire the wisdom of the parable and their correspondence to what exists, is their statement. When the serpent came to Eve, it cast pollution into her. The pollution of the sons of Israel who had been present at Mount Sinai has come to an end. And for the pollution of the nations who had not been present at Mount Sinai, their pollution has not come to an end. This too you should follow up in your thought. Okay. Here, Maimonides is simply is implicitly engaging in a polemic against Christianity. Contrary to the Christian condemnation of the Jewish tradition for its legalistic frame of mind, the Jewish narrative speaks of redemption from the original sin through law. Furthermore, and as we will progressively come to see, contrary to Paul, who replaced law with grace, the Torah, Jewish law, is itself an act of divine giving. The Torah is thus a binding law, which is transmitted through the generations. There are three characteristics of this law that distinguish it both from positive law and from natural law, and which are extremely relevant for sort of a counter jurisprudence to the one we commonly associate with human rights. Torah is first and foremost a transmitted law, that is, a law, the authority of which lies in tradition. The reason why the law is binding for Jews is because they received the Torah as a living tradition from their forefathers across the ages. Unlike the eternal natural law, Jewish law is temporal, but unlike transient positive law, Jewish law is unalterable. Second, the Torah is an unwritten law. Indeed, according to Jewish tradition, the law received at Sinai has two parts, written and oral, and it's the latter that takes precedent over the former. The Torah for Maimonides is unwritten law in the strong sense, not simply because it was not written, because it cannot be grounded by its writing. Its content cannot be summed up in principles or in generalizations the way in which a natural law can be, nor is it reducible to sovereign commandments as positive law is. It is a living tradition that requires interpretation. Finally, the Torah is the law of the people as a people. It is neither territorial nor universal, it is communal. These three characteristics of the Torah, eternal yet given, communal, neither global nor territorial, and singular, neither generalizable nor arbitrary, are not unique. They are characteristics of tradition as a source of authority. However, what makes Maimonides' interpretation of Jewish law valuable for our purposes is his attempt to make philosophical sense of tradition, specifically attempts to make sense of the binding force of the Torah authority by pushing philosophical thinking beyond the limit of Aristotelian knowledge, and of course by an attempt to interpret key aspects of the Torah, both the giving of both the sin and the giving of the Torah at Sinai, as well as creation, as we shall see in a minute. In other words, the pressing task before Maimonides is not to justify a specific this or that legal precept, nor to justify the Torah as a whole. Rather, the ultimate challenge for him is to make sense of the kind of law the Torah is. Ultimately, the question from Maimonides is not how can revelation justify law, but rather how can we make sense of revelation to begin with? What, in other words, is the philosophical point, so to speak, of the writing of the unwritable? That is, of the encoding of the eternal and temporal language. Neither the question nor the answer are explicit in the guide, and purposefully so. And this has to do with the way that the guide operates. Now, Ruth, please tell me how much time I have so that I can try and see where I go from here. I can't hear you.
Half a minute.
Half a minute? No, that's not fair. Okay.
1.5.
Okay, so let me then say where this goes from here. I guess I should jump right to the end then of the guide, where I think much comes to play. At the end of the guide is quite perplexing in itself. It ends actually with a discussion of chesed, of not only of chesed, but of chok tzedakah, mishpat tzedakah v'chesed. That is chesed understood as a Jewish grace. And I think that it's important that the book concludes with that. There's a sense in which, and here again, one would need to elaborate, there's a sense in which the Torah itself and the giving of the Torah is understood as a benevolence of God to humanity walking in darkness, so that the giving of the Torah is in a way an indication of the law that God is giving to the people, and also an understanding of tradition as the gift of tradition. If and given the limits of time, I just want to tie this back to the question of human rights and say two things. On the one hand, what was important for me in this talk is to emphasize the abyss or the gap between the Bible, as I read it as the Torah, and the conception of human rights, specifically the tradition of natural law, but also the entrapment of the distinction between natural law and positive law. So on the one hand, it's an emphasis on the importance of a different kind of jurisprudence that has its ground in tradition and in a story of the giving of the law and the creation of the world, which I had less time to talk about today. On the other hand, we can come back and revert back to human rights with this understanding and ask ourselves whether there's another alternative possible reading of human rights, not in terms of natural law or positive law, but rather as our tradition. And what would that mean? To think of natural law not through a universalism, but rather through a particularistic tradition. And bearing in mind that this particularistic tradition would bring with it a certain kind of humility, both in understanding of human knowledge and the limitations of human power. And what would that understanding of human rights propose to us? In other words, even if we decided to declare the death of God, or perhaps the fact that God has concealed himself from us, his presence, absence, it would still be a question of where that leaves us and whether the conclusion is a radical break from our traditions and from the sense of tradition, or kind of trying to come to grips with the fact that we are not all that different from the ancients. Thank you.
Thank you so much, Shai. And we will continue immediately with Sharon. Then, as you've done in the previous panel, you will react to each other, and then we'll have perhaps some time for a few questions. So Sharon, please.
Vivian, could you allow sharing, please, of the slides?
Sure.
Okay, so I'll start by thanking you for inviting me to this. This is really, I mean, we always say thank you, but this is really exciting for me. I feel like going back home, doing this mix of law and humanities. So thank you for that. And I will bring a lawyer's perspective into the mix. So a proper lawyer, not a biblical scholar. So I've been reading the Bible all my life, and I've been reading law many years of my life, but bringing my legal expertise into reading the Bible was an interesting exercise to me, and I hope also to you. So I'll discuss the biblical right, quote unquote, to family, which I think offers a different view on what's most important in life. Let's start. Right, so as a lawyer, when I start looking at human rights, I go to the international documents. We can also go into national documents, but the international documents do a good job here. So the Universal Declaration for Human Rights, for example, stresses the natural and fundamental understanding of the family as the group, the unit group of society, and mentions the fact that the family is entitled to protection by society and the state. The same idea repeats itself in other international documents. You can see here 3 other examples. So basically, we have this understanding that the family is essential and mustn't be harmed, right? So we have a human right to family, meaning the meaning of a human right means that we acknowledge the importance of the family and we do not allow harming the family. Now, when looking into the actual rights protected, it seems that the international documents focus on family, hence on marriage, sorry, hence family is marriage, where we could have thought that family is other things, family is marriage. And here again, I go back to the 4 international documents I mentioned before, and they all discuss the right to marriage in one way or another. Some of them might briefly mention children, but they will do it in a different sense, so not as a part of the right to family. One of them mentions the right of women to postpartum protection, but then again, it's not really a part of the right. It's a limited part of the right to family, and this is only in one of the documents. So what we have so far is that the modern right to family is a broadly recognized right, because we see it in 4 different international documents, all are very well accepted, protected by various legal tools in the following way. So first, we understand the right to be an individual benefit to which every person is entitled. Second, we see it as a negative right. So it's the right to be left alone. The family has the right not to be harmed by others. In US law, where the right to family is part of the right to privacy, they call it the right to be left alone. So you can sue if somebody didn't leave you alone, right? The third point is that the right raises a cause of action. You can sue. It's not just a theoretical right. It's not just a general right. And fourth, it is centered around marriage and couples. So family is couples. And actually, if you look at modern family law textbooks, you will see that the biggest chunk would be discussing the creation and dissolution and the ramifications of marriage. Then you will have a far smaller part discussing children. And then you will have all kinds of miscellaneous, domestic violence, etc. But the main part would be the creation and dissolution of marriage. Okay, so this is the more modern take on the right to family. And then I take this understanding and I go to the Bible with 3 questions. The first question I have is, what is the center of the family? So is it about marriage in the Bible as well? The second question I have is there a right to family? And here already some of my predecessors mentioned there, I think there isn't, and I will explain later on. So there's no entitlement and no cause of action. And the third question would be, what does it mean? So is it an individual right? What kind of right is it? Okay, and now let's go into details. So the center of the biblical family is not the couples, right? So in the biblical narrative, couples are not the main point of interest. Even when marriage is mentioned, when it is harmed, a spouse might not have a legitimate recourse at all, right? And I have here, I think, 2 beautiful examples. So the first is the famous example of Abraham is going to Gerar. He meets there the king Abimelech, and he just plainly, and I'll read the Hebrew text, but you have the English if you prefer. So he just tells his wife, Vayomer Avraham el Sarah, achoti. So just say you're my sister. There's no discussion. Nobody says, but I have a right, let's sue. Just say you're my sister. וישלח אבימלך מלך גרר ויקח את שרה, ויבוא אלוהים אל אבימלך בחלום הלילה. So here there is some kind of reaction from God, and here we will see what kind of infringement is the action of Avimelech. So ויאמר לו, הנך מת על האישה אשר לקחת והיא בעולת בעל, ויאמר אליו האלוהים בחלום, גם אנוכי ידעתי כי בתום לבבך עשית זאת, ואחסוך גם אנוכי אותך מחתו לי, על כן לא נתתיך לנגוע אליה. Meaning, God says, when you did this, you didn't sin to Abraham. You didn't harm or infringe upon the right of Abraham. You infringed upon my laws. You sinned to me. I protected you not to sin to me. Therefore, I didn't let you touch her. So there's nothing here about the relationship between Abraham and Sarah. It's only the business of God. Okay. A more, I think, potent example is one of the saddest story in the Bible. It's very short, but it's touching if you're into this kind of literature. So, sorry. So there's the story of Paltiel ben Laish. His wife has been taken from him, right? וישלח דוד מלאכים אל איש בושת בן שאול לאמור, תנה את אשתי את מיכל אשר הרסתי לי במאה עולות פלישתים. There was a deal between Shaul and David. David now deserves Michal. Michal is married to Paltiel ben Laish. David sues, but not on the right to marriage. He sues on the right to breach of promise, right? Give me my promise. וישלח איש בושת ויקחה מאם איש מאם פלטיאל בן לaish. And now here is the sad story. וילך איתה אישה הלוך ובכו אחריה עד בחורים. ויאמר אליו אבנר לך שוב וישוב. Meaning, this man follows his wife crying all the way. He doesn't want her to be taken. He wants her back. And then a guy comes to him and says to him, just go. And what does he do? He doesn't say, but this is my wife. You can't take her away. No, he just goes. Right. So granted, those both are stories involving kings, and you can say it's the prerogative of a king to do something that is not within the law, but those are the examples we have. So marriage is not something you can sue, you can cry about it, but you can't sue about it. Okay. So not couples, but children. It seems that even when the biblical story acknowledges spousal love, and we have the examples, Yitzchak v'Rivka, Yaakov v'Rachel, this love is not central to the story. It's very nice that the narrator mentions it, but it's not central to the story. The biblical stories are intensely occupied with having children, right? So we know Genesis is the biggest fertility clinic in literature, I think. Everybody there has issues. Judges, the same. Samuel, Ruth, etc. And most importantly, the promise to have children is central to the inception of the relationship between God and Abraham and his descendants. And here we have it. So and here I move to the question of right? The inception of the relationship between God and Abraham starts in Lech Lecha, right? And Abraham gets a promise, and the promise is later repeated, Brit Bein HaBetarim, etc. It's repeated many times over, but this is the first one. ויאמר השם אל אברהם, לך לך מארצך וממולדתך ומבית אביך אל הארץ אשר אראך. And here is the promise. You do this, you leave your home country and go elsewhere, and what I will do, ואעשך לגוי גדול ואברכך ואגדלה שמך והיה ברכה. Right? God makes a promise, you do this, I'll do that, and then we have אברהם feeling his end of the bargain, וילך אברהם כאשר דיבר אליו השם, וילך איתו לוט, ואברהם בן 5 שנים ו70 שנה בצאתו מחרן, meaning we already know that Abraham is an old man, but still he got the promise and he fulfilled, he did his bit, and now we expect God to, maybe it's not right, maybe it's based on a promise, we accept God now to do his part. But that doesn't happen, right? Even though Abraham got this promise and paid in cash, right? He moved. Abraham does not say a word when his promised child isn't born. And for many years, he's not born, right? Many years he's waiting. And then once this child is born, there's the story of Akedat Yitzchak. Abraham is ordered to sacrifice this son. And he never says a word. He never says, but you promised. Not only does he not say, this is my right, he doesn't even say you promised, right? So Abraham's descendants, so not only Abraham himself does not sue based on the promise, his descendants don't do it either, right? So for example, if you're Yitzchak, your father was promised this is the relationship, this is the core of the relationship between the Abrahamic family and God. So Yitzchak could have said, wait a minute, why should I cry and pray for having children? You promised, right? But nevertheless, even Abraham's children, they never count on the promise. They never make any demands based on it. Instead, they pray and ask for mercy. And again, a very beautiful verse. ויתר יצחק להשם לנוכח אשתו כי עקרי ויעתר לו השם. Meaning, the couple stands and begs for mercy. They don't say, we deserve it. We just say, please give it to us, right? So we are centered around children, but we're not centered around rights in the sense that I can sue or I have a claim, right? Even though this is central to my life, I have to ask. Nobody has to give me anything. Okay. And here we go to the etymology of rights, which was already mentioned in the previous panel. So indeed, it seems that the Bible does not acknowledge rights in the modern sense. The word zchut, so in Hebrew we call human rights zchuyot adam. The word zchut does not appear in the Bible at all. It first appears in the Mishnah, which is not part of this conference, the discussion of this conference, but still I brought the context. So in the Mishnah, for example, in Sutta, the word zchut does not mean a right, but merit. So ואם יש לה זכות הייתה תולה לה, meaning if she's a righteous woman, if she is of merit, her punishment will be delayed or she will be saved. Okay, so there's no notion of rights, I think, in the Bible. The Bible does not discuss rights. Okay. Not rights, but merits. So the biblical world is a stranger to a right-based thinking. Even where there is a promise of reward, this reward cannot be demanded. Instead, the biblical world is one of divine favor, okay, given to those who are of merit or completely arbitrarily, meaning there isn't such a thing as a human right in any aspect, and particularly not a human right to family. The only right you have is the right to beg, maybe, but that is it. Okay, so what is the nature of the biblical family? So the biblical family gives us these findings so far. So not only is the center of the discussion children rather than spouses, and there is no right to family, but the biblical conceptualization is different than the modern one in another way, which is the biblical family is not centered around the individual. And this, I think, is mind-boggling to modern lawyers who think of rights, even when we discuss group rights, they sometimes stem from the right of the individuals within the group, right? So I have a right to culture, for example, hence my culture is protected. I think it would be very strange to modern lawyers to think of the right to family as a group right in the sense of not the right of individuals, but there we have it. And here is why I think so. So I think the right to family in the Bible means the right to heritage. When infertility is a prevalent phenomenon in the Bible, while infertility is a prevalent phenomenon in the Bible, very few cases focus on the pain of the childless woman, right? If we would think about it as an individual right, and in modern law, we do think of it as an individual right, we discuss the pain of those who are deprived. one notable case where this actually, where the pain of the deprived is discussed is in Genesis 30. The case Rachel does not have children, Leah has quite a few. ותרא רחל כי לא ילדה ליעקב, ותקנא רחל באחותה, ותאמר אל יעקב הבה לי בנים ואם אין מתה אנוכי. Now here we have two things to unpack. First off, why is she jealous over her sister? And second, what is the meaning of give me children or give me sons, otherwise I die, right? Is this a threat? Is this, what is this? So I think this says two things. So far in the Abrahamic family, one woman continued the line, right? So there was Sarah, then Rachel. Yaakov has two wives. She's not just jealous of her sister. Rachel says something else. Rachel says, look, you have the promise because you are of Abrahamic descent, right? So God's promise to Abraham will be fulfilled through you. But you've already fulfilled your promise through your other wife, my sister, right? So she's not jealous in the sense of modern jealousy, or maybe she is, but I argue, or I suggest maybe reading it as a different story. She is jealous because she says, here is the line and I'm not part of it. One of us had to take it and she took it. So now I'm lost. And this is why she says, Im ein meta anuchi. My line does not continue here. So it's not just the fact that I want to have children because I want to have children. It's the fact that I want to be continued. My line could be severed here if we only understand the Abrahamic line as continuing through one of your wife, either or, and she's the one who continues. So I think even when we mention the wife's or the woman's pain, we really tell a story of continuum of a family rather than individual pain. And here is the point where, here's the place where the point of family as heritage is, I think, most helpful, at least to me. So I've been preoccupied for many years with the story of Job, which is very hard to digest, I think we all agree. And we know that, so first off, we know that Job is a nice guy, right? So if anybody should have a right, this is the man to have a right, right? He has a right, he has a merit, he's a good guy. Nevertheless, we know the story, he loses everything, he gets to bare bottom. And from there, when God settles the business with Satan, with the devil, he has to be brought back, he has to be built again, right? And the book of Job, so I have the first verse and the final verses of Job here, of Job. In the final verses, and some of them here, here's what we have. Meaning God gave Job more in the end than he had before. And one of the things he has more here is so for many years and even when I'm explaining this, I still have some gut feeling that cannot understand what is the compensation for dead children. I mean, God, if we believe that God could do anything, God could have resurrected the lost children. This would have been a compensation in the modern world, right? In the modern world, we would think that there's nothing to compensate for a lost child, right? A lost child is a lost relationship, is the lost potential, promise, love. There's nothing that could compensate for it except for the thing itself. Yet, for some reason, we're expected to believe that Job has new children, other children, and this is okay somehow. We could leave it at that and say that the story of Job is inexplicable, and for many years this was my understanding, and it might still be my understanding of the story, but I want to propose that maybe we were given some sort of small conciliation here. And the small conciliation is this: if we understand the story of children and the right to children as the right to heritage or to continuum, then Job got it, actually, because he got two things. First of all, he got children to continue himself through. And moreover, he got to see the continuum. So it's not just the children, it's the children's children and their children. So he got to see his line moving on in the world, right? Again, I'm not saying you have to buy into this, but this is an explanation. So here we go to maybe my bottom line. What's most important in life? Biblical thought and modern families. Now, I teach family law, and I think, so we could have said, you know, the Bible is an obsolete story, it is irrelevant to us, or we could say the Bible could give us something. And I think, and I'll give you what I think we take out of it, and then I'll say what I think we could take out of it for modern family law, without being apologetic about what's in the text, because I grant you that the text is not easy to modern listener. I think the text gives us, so the first point would be not isolation, but relationship and intervention. Sorry. So if I said before that the modern right to family thinks about the non-intervention, right? I have the right to be left alone. Nobody should harm my family. And we could see that the modern text did not say the state has to do everything in its power to support the family. The state has to enable proper education, proper life, to have everything that you need. The state just, the documents just said you should not be harmed. The Bible tells us it's not about isolation, right? Everything, in order to get something, it all revolves around relationships. First, your relationship with the divine intervention. You have to ask God for something, and then your relationship with others, with your king, with your wife, with your children. So and I think this is an important point, particularly to modern jurists who think of rights as an individual project. So the Bible suggests that it is not an individual project. The second point is not demanding, but asking. And here again, in the modern legal framework, this would be, I think, unacceptable. But the Bible tells us, so the two meanings of zchut basically tell us this. The Bible focuses on the rights, but the rights are merits, really. So we understand rights in the Bible through the concept of merit, whereas modern law does not think of merit, right? So we know that human rights are unalienable. Everybody has them, regardless of behavior, regardless of how nice they are, they have them. The Bible does not think so. The Bible thinks that everything you get for, you could either get it or not get it. It's not yours, right? So even if the case of the Abrahamic bloodline, where there was a promise, there's nothing to sue. There's no actionable right here. You can't say you have a right, even when you have a promise, which I think, modern law is basically grounded on the understanding that promises should be kept, right? This is contract law. The biblical law does not think so, right? And the third point would be not focusing on me and on now, but on us and the future, meaning what you get, you don't get for yourself, but for your group, and you don't get for now, but for your generations. So the significance of bloodlines and heritage, as opposed to fulfilling your needs and wants at this very moment. In modern family law, we don't have those. We have rights which are given to the individual, which are very minimal, and they should do. But the more I read family law, and it's very depressing, so I try to stop doing that, but the more I read family law, the more I'm convinced that rights will not solve our problems. And we have growing body of literature saying that courts cannot save the problem of families and law cannot save the problem of families, because rights are strong shapes that do not coexist, do not work together, right? There's a famous poem by Yehuda Amichai, in the place where we are right, there will never be flowers in the spring, because it's too strong, it's too rigid. And there's an emerging body of literature in family law, but also in other parts of law, discussing the ethics of care. The ethics of care creates not a right, but an obligation on one to care for others around them, even if they don't have a right. So for example, you have to care for your ex-spouse. If that ex-spouse needs care, you have to support them, you have to promote them. If that person cannot survive by themselves, because when you created a family, you created a duty of care. Similar arguments are made in criminal law and in welfare law, all kinds of other contexts. But in this sense, I think maybe what we see here is a beautiful full circle, where we think that the biblical norms are outdated and dated and irrelevant and strange, but then really reading it as a modern lawyer, I think the biblical norms really are at the forefront of science, right? At the forefront of our scholarship and promotion of the field, because basically they tell us that rights are nice and good, but they're impractical. And then maybe the Bible is Torat Chaim, or a higher level kind of document, in the sense that it already knows that the rights are important but impractical. And if you think you deserve something but you don't ask for it, then maybe there's no point for the entire endeavor. Yeah, so that's it. Thank you.
Thank you so much, Sharon. Two fascinating lectures, and I'll ask you now, Shai and Sharon, to react to each other. So Perhaps Sharon, you would like to start, or you want to a moment of rest after your very energetic talk.
You mean by energetic too quick? I'm sorry. I can make a small point to whenever Shai speaks, I always just take lots of notes and hope I get everything, because it's always lofty ideas. But if I got you correctly, what I did get from you is I think there are many levels of the law, and you combine them together, and this may be, to me, it was misleading a bit in the following sense. So the law is, and you mentioned all of those concepts, the law is mishpat, the law, and also ethics, and also religion, and also tradition. And every one of those is a different, so I agree that all of them are in a sense part of a legal system, but they're not all the law, and they would behave differently, right? So I like, in the end, I think we came to a similar conclusion, because you said something about human rights and tradition and not using this universal understanding, but more context understandings. But I'm thinking there is something here about unpacking the four understandings and seeing what works for each of those, if that makes sense.
Thank you. Perfect sense. So I'll respond in a minute, but I just want to return a favor and kind of tie the papers together, and then I'll also answer your question. So in a way, so I was very happy with your paper in itself, and then also in a way that it both touches and in a way, in my interpretation, says something similar to what I was saying, but also differs. So I think that there are 2 points you were making in your paper and 2 points that I was making in my paper, and they could be seen as identical. You were saying it's about heritage. I was saying it's about tradition. And what the heritage and tradition share in common is the specific relationship of sort of a legacy, of moving from past to future, and the importance of this connection and the way it plays out in family law and your interpretation of family law. The key is having this legacy, having the possibility of sort of transferring whatever it is from father to son, perhaps just parenthood. And the second point that you were making is the point about that we don't deserve it. We don't, it's not our right to receive. And that's what I was talking about when I was talking about sort of the idea of the gift of knowledge and the gift of law. And in that sense, we're saying abstractly the same. But then there's a way in which you try to then translate this into a jurisprudence, and you did it by universalizing. And so I wanted to ask you about that. And so you wanted to make it close to something that would be palatable to our contemporary sensitivities and sensibilities, but I think something is missing when you do that. And it's, so first of all, it's not simply that we don't deserve it, but in the case of Abraham and Job, what is key is that we don't understand it. It's not, we don't understand what's going on there. And I think that that's what I was referring to when I was talking about the fact that the law is groundless but not arbitrary. And this is right. So in a way, God, we don't understand it, but it's not arbitrary. It's a gift, and that's key for you. And then when you were talking about heritage, yes, heritage is probably an important concept in ancient law, but in the biblical story, it's not about heritage in general. It's a particular lineage that's at stake. And it's a very particularistic story about a tradition that passes from Abraham onwards that the Bible is concerned with, to the extent that even God is bound by that tradition. That is, God can't ultimately require Abraham to sacrifice Isaac, right? Because God is also so I think that this is the way in which the move to human rights, the move to universalize, actually misses an important component in the story. To your question, as to my paper, yes, I think it's essential for my jurisprudential understanding that we don't distinguish between these four. That law and ethics and religion, and I forget what else was there in the list, and ethics are part of a unified whole. And I think that it plays out also in your story. That is, family law is not just going to court. Family law is both about the relations between humans and the king, and that's one story you have. It's a relation to God. That's another. So you were also, I think, playing in your paper with different dimensions of law, seeing them as related, precisely because I think in that context they are, and that it's important to see the way that the narrative actually, and your narrative, moves from one layer to the other.
Thank you for both of you.